This program is brought to you by Emory University.
Ladies and gentlemen, guests and colleagues, it's a great privilege to welcome you back to our conference on What's Wrong with Rights for Children. Thank you so much for being here. Welcome back to those of you that were here yesterday. Yesterday, we spent some time parsing the politics and the provisions and the promises of the 1989 UN Convention on the Rights of the Child and some of the philosophy of children's rights more generally. We also began to address some of the tender questions surrounding U.S. ratification of this 1989 UN Convention. The question of ratification and implementation will be moving to the top of our agenda today. We'll be spending some time surveying the state of children's rights in our country and in several countries around the world, and use that as a basis for assessing the wisdom and the worries about implementing the convention should ratification be in the offing. We begin our morning with another very high-powered panel discussion. Chairing our first panel is a colleague who has done more than anyone in this building to promote the cause of children's rights, and that is my friend, and I am proud to say my former student, Professor Karen L. Worthington. Professor Worthington is director of the Barton Child Law and Policy Clinic and director of the Southern Juvenile Defender Center, both pioneering initiatives here at the Emory Law School. She teaches courses on child advocacy and various clinical programs on behalf of children. Her primary areas of focus are treatment of children in state custody and improvement of the systems responsible for the care of those children so positioned, a topic that she pursues with great alacrity and effectiveness before state, local, and national agencies and administrative bodies. Professor Worthington will be chairing our proceedings this morning. Will you please join me in welcoming her to this lectern?
Good morning. I am honored to be chairing this panel and introducing this morning's speakers, who are two of the world's foremost experts on the intersection of government and intimate relations. So I can't wait to hear what they have to say about children's rights, what's wrong with that, and what the role of the government and the international human rights movements should be in this area. First, we'll hear from Martha Albertson Feynman, who's a Robert Woodruff Professor of Law here at Emory University, as well as the director of the Feminism and Legal Theory Project. She's the author of numerous books. Two of her most recent are Feminism Confronts Homo Economicus, Gender Law and Social Policy, and I had to ask, because I haven't read the book yet, but it's on my list. Homo Economicus is Economic Man, and she's also recently written The Autonomy Myth, A Theory of Dependency. Martha came to us a couple years ago, and we were thrilled to bring her here for both her work in the United States as well as internationally in bringing together scholars and experts on human rights, gender and sexuality, intimate relations, and children's rights. So we're thrilled to have her here today. Our second speaker is Marty Guggenheim, who's visiting us from New York University School of Law, also an author of many books. His most recent, very provocative, I know you've heard that term a lot and used with this, What's Wrong with Children's Rights? We'll hear from him today. He has served as the director of the clinical and advocacy programs at NYU and was the director of the Washington Square Legal Services for a number of years. He's taught the juvenile rights clinics. He has represented parents before the United States Supreme Court and is one of our leading experts on children's rights and parents' rights in this country. So please welcome our panelists.
Well, I'm really pleased to be here at this very important conference, and very interesting conference too, I might add. What I'm going to talk about is the title of this session, which, like the larger conference, is entitled, What is Wrong with Children's Rights? While some things might well be wrong with children's rights, I think there's one important thing that is very right with children's rights, and that is the possibility that is inherent in the concept of rights for children. Claiming rights for children has the possibility of enhancing children's well-being at a very practical level. It can do so because the very discussion of rights engages a political process that has the potential to result in transformation of cultural and eventually adjust law and policy in a more progressive direction. This is not the same as saying that it has a legal process. It is, in fact, a cultural process, a political process. Political transformation is what's happening in the UK, in England, Scotland, Wales, and Northern Ireland. This transformation is not complete. There's a lot of tension, questions, debates, but it is definitely underway. The UK represents an interesting point of comparison with what's going on in the United States. We, of course, have much in common with the UK, including a language, kind of. We have a shared early legal history, similar legal and political cultures. Many of the concepts and processes we employ are the same. Yet the reaction to the idea of introducing international human rights standards into domestic law has been very different. Again, not that the UK has embraced without reservation the idea of children's rights. It has been a struggle and still is a struggle, but the UK ratified the Convention on the Rights of the Child in 1991, just a few years after it was promulgated. It was no big deal. Why were they so much more willing to accept the convention? There are differences in our proximity to the international community. Americans are privileged, perhaps, geographically. We have few neighbors, and those that we do have are friendly. The UK has had to act more collaboratively with its neighbors, be more tolerant and accommodating, even accepting of new foreign ideas. America's relative isolation is reflected in our attitudes towards other countries. We don't even want to go visit them. Only 20% of Americans have passports, and if other countries aren't worth visiting, then they can hardly serve as a model for us in our legal system. We also don't know much about what's happening in other societies, and this is true even for academics and intellectuals. The news coverage of the world is sparse, typically sparse, in United States newspapers. And comparative law and international law are not required subjects in most law schools and are not part of those subjects that are required in our law schools. There are other differences that may be relevant to an understanding of the U.S.'s position on the convention. President Carter actually mentioned several of these yesterday. He noted that our view of our place in the world leads to the idea of American exceptionalism. This is another way of saying America has an exemption from the rules that govern the rest of the world. Also, on our belief that exceptionalism gives us the right, we think, to act unilaterally. Second, our federalism and a preference for local rather than national government action in regard to family matters makes us suspicious of national mandates imposed on the states. I would add to those things that President Carter mentioned that we are more resistant to recognizing the need for changes in law and policy than some of our cousins. Canada and Australia and even the UK are more accepting of an evolutionary notion of rights. They see that there's a need for a reevaluation, a consideration of the possibility for change as thinking evolves and circumstances are altered. Now here, I'm thinking in regard to the United States of our debates about whether we have a living constitution or our judges are bound by the original intent of the framers of the Constitution in interpreting that document and the Bill of Rights. This, of course, is a struggle today as we debate whether we want activist judges or those who merely apply the law. Speaking of the Constitution, our Constitution, and its conservative nature, our Constitution is rooted in the 19th century. It's concerned with placing restraints on the government. Our Constitution does not guarantee positive rights to social and economic goods, as do European and some other welfare state systems. There's a different way. We have a different way of thinking about the obligation that government owes to its citizens, and our obligation is more procedural than substantive. I think we are also much more suspicious of experts as a nation. We are distrustful of intellectuals and academics, a kind of perverted version of egalitarianism that raises gut feelings and uninformed hunches or actually in the case of intelligent design, belief, to the level of decisions that are anchored in the experiment, education, and experience. We tend to be skeptical of professionalism and of those that are cosmopolitan. And I think we have a deep and cynical suspicion of any collective action, what we like to call special interests, in an effort to discredit groups who might come together for some cause, be they cartels, trade unions, or people working to eradicate HIV and AIDS. And then there is our related, famously replicated frontier mentality, the nationalistic image of the relentless, lone, rugged individual taming the wilds and proving his mettle against gigantic odds. Such cultural predispositions affect our reception of the idea of children's rights. In fact, they affect our attitudes about any rights, and certainly our opinions about the government's role in ensuring rights. I mention this rather distinctive collection of American tendencies not to suggest that they are universal across Americans. There is a great deal of contest in our culture about these things, and in fact, we have a cultural war currently underway. But I think that those who fear the Convention on the Rights of the Child are correct to do so. On a very fundamental level, the Convention on the Rights of the Child is threatening to one vision of the American way of life, to American destiny. The Convention on the Rights of the Child is threatening to the culture of America as superior and supreme. Acceptance of the convention could be viewed as a concession that the rest of the world, those other nations who are now busily creating a jurisprudence of the rights of the child, have the right to tell us what we should be doing, how we should be acting. Our place in the world might be viewed as more equal than exceptional, and we would have to embrace some of that multinational attitude that Canada is so rightly proud of. Our local government would lose control, at least to some extent, to the overarching standards incorporated at the national level, which in turn were imposed by the international. And given the CRC process, change might be the order of the day instead of something to be resisted. Change, evolution, might be seen as inevitable in a collaborative system that's premised on constant reevaluation, reporting, and suggestions for change in order to make yourself better. Change that would be directed outside of our control. Can you imagine the distress for Justices Scalia and Thomas and their fans if those, quote, foreign fads of international human rights that were so important to the bare majority of Lawrence versus Texas were domesticated and routinely used to assess our constitutional principles? Opposition to the CRC is not irrational, as it was labeled yesterday, at least not from the perspective of someone quite satisfied with the status quo in America. But I want to go back to the UK. I describe the process in the UK as political. It is also educational and symbolically and pragmatically significant. First, on the ground of substance, there was a great deal of productive debate about what might constitute rights for children in this process of considering the CRC, whether children's rights must of necessity differ in substance from what constituted rights for adults. Debate helped to define the issue, even resolve them in terms of a bottom line. Children do have rights in the UK. This is symbolically and practically important, although the debate about the nature and content of those rights continues. It's an ongoing process. Rights are better understood as a result of debate. Many of those that were initially resistant to giving rights for children were in fact focused on rights as embodying liberty interests. They understood rights to be the right to self-determination or autonomy. This is often designated, of course, as the basic right of autonomous individuals. But self-determination presupposes the capacity to make appropriate choices. And it is clear that children, particularly young children, do not have the same capacity as adults to make appropriate choices. In fact, there's a competing objective that is also part of the CRC, the responsibility of adults to safeguard children's welfare. This is the protection principle, And the proponents of children's rights, making children have rights, made several points on the capacity issue. For one thing, and first, self-determination can be a gradual process of realization. A child of 16 is more capable of exercising autonomy and judgment than a child under the age of 5. This point was made yesterday. And in fact, the CRC suggests that some balance is necessary. We should be able to both respect children's choices and have the ability to override those choices if they would result in harm to the child. The important determination in the UK was that the need to fulfill the child's right to protection should not undermine the responsibility to promote the child's evolving capacity for self-determination. CRC Article 14 provides that parents' right to provide direction to the child must be in a manner consistent with the evolving capacity of the child, and the preamble, while recognizing the importance of family and requiring the states to respect the rights and duties of parents, goes on to define a duty to provide in a manner consistent with the evolving capacities of the child, appropriate direction and guidance in the exercise of the child of the rights recognized in the present convention. This attention to the evolving capacity of children allows a child to have rights, even if initially and temporarily qualified in their exercise by the need for protection. But the possession of rights is an important victory for children. The designation of the rights of the child as a rights holder repositions the child in the family and in society. Children are not the possessions of their parents, nor are they merely future citizens of the state. As individual child evolves, so will their understanding of the rights under the CRC. Children as right holders are not simply passive recipients of benevolent treatment by adults acting in their best interest, caught between the twin oppressions of family privacy and privatized dependency on the one hand, and state deference and non-intervention mandates on the other. Children are more than that. They are human beings with rights. There's a second point that was made that's relevant in this debate about capacity. One of the rights that CRC sets out is the right of the child to participation. And participation is not the same as self-determination. Even if we are uncomfortable with adult-level self-determination for children, that does not mean that children do not have or should not have a right to participate, to be consulted when there are major decisions that are being made that will affect their lives. The Children's Act in Scotland recognizes such a right when it establishes that children over 12 must be consulted about major decisions having to do with their upbringing, and this was enacted in 1995. And the CRC generally encourages more participation as a general matter. In addition, as has already been noted, the CRC imports many other types of rights in addition to these participation rights or self-determination rights. Particularly social and economic obligations, I think, are significant, and these are placed upon the state or society. In this regard, a designation that a group has such rights is one powerful way to direct society's priorities and society's resources, to bring the state's affirmative responsibility to the foreground. Social and economic rights of the child can be used to build a child-centered progressive politics, and that's happening in the UK. And for children, a group that has historically been left out of the centers of decision-making power, in fact, doesn't even have the right to vote, and whose interests have only been factored in through others, rights are important because they are universal. Rights for children apply to all children. So it's not just the poor child, the non-marital child, the child in need of education that becomes the legitimate focus of state concern. In fact, if we do that, if we fragment the concept of childhood, then it's easier to kind of serially ignore children in their individual defined categories. In addition to the substantive debate, the UK also underwent some structural and procedural adaptations as the result of accepting the Convention on the Rights of the Child. Again, it was ratified in 1991. But the ratification did not make the convention UK law as such. It was not part of the law of England. So the CRC initially served as a template with which to measure domestic standards, and I don't want to minimize the importance of that. That is important. The CRC was a very useful tool in educating the public and in educating governmental officials about the need to change our attitudes about children and their potential to be rights holders. It was an important symbolic statement that altered the debate, that really began to reshape the debate in the UK. And in fact, this educative function is built in Article 42 of the CRC, requires that the government make its provisions widely known among all. The CRC also served to generate domestic pressure for further reform, for implementing legislation that would bring the principles into the domestic law. And a very important measure in this regard was the Committee on the Rights of the Child, which was mentioned also yesterday, this international monitoring body. The committee is composed of 10 experts who are elected by member states. Each member state is responsible for submitting a report 2 years after ratification, and then must report at 5-year intervals to the committee. The process does not rely totally on the subjectivity or objectivity and openness of the member states. The committee also collects information from other sources and generally collects comments from NGOs and other groups, assessing whether the report that the member state presents to it is accurate and comprehensive and complete. This sets up a system of checks that are designed to be as open as possible and to allow for a dialogue, for a process of presentation, reporting, and then criticism of the state's process. The committee will compile a list of issues that require further explanation and ultimately prepares a final report and concluding observations which will identify and critique areas of noncompliance and make suggestions for corrections or remedy. This openness of the reporting process means that the domestic and the international communities have access to the perceived shortcomings and failures of an individual country. So shame might work as a motivator, as well as an incentive for criticism, for mobilizing critics. In fact, the first 2 reports on the UK generated a lot of criticism and many suggestions for reform. The critiques from the committee were that the age of criminal responsibility was too low. The law's response to corporal punishment was inadequate. There was a lack of children's rights in the educational sphere, and there was a lack of children's participation generally in the decision-making process. So these were the kinds of critiques that the committee issued in regard to the UK. Child advocates used this process to present even harsher criticisms of the UK and actually to highlight the limitations of the committee process in the CRC itself. The allegation was that the committee does not carry with it an effective enforcement mechanism. So while it's good in terms of making things open, part of the process, it does not have a really effective enforcement mechanism. The committee was years behind in its work. It was underfunded and overwhelmed. Critics were able to use the reporting process to muster constructive suggestions for changes in domestic law. They were able to argue for implementing legislation, which came in the form of the Children's Act. Once the rights, the fact that children had rights was conceded, then the political issue became one of implementation. I think that one of the most important aspects of this second round of implementation was the suggestion that a commissioner for children be established. And this was established first in Scotland and then Wales and then I believe Northern Ireland and England. This commissioner for children's rights was a structural innovation that had been developed in other states and was put in place to create an independent advocate for children. This advocate had the explicit responsibility for oversight in regard to the interests of children in that society. The commissioner, who assumed responsibility for overseeing implementation of children's rights, used the standards that were set forth, or was mandated to use the standards set forth on the Convention for the Rights of the Child. And this commissioner then replaced a fragmented system where responsibility for children was spread over a variety of institutions in the UK. Now, the commissioner does not have responsibility for individual cases, so they're not an advocate for individual children, but has the important role of conducting an evaluation of legislation and proposed legislation of relevance to children. They have 5 areas that they're to be concerned with. The first is the physical and mental health of children. The second is protection from harm and neglect. The third is education and training. The fourth is the contribution of the child to society. And the fifth is the social and economic well-being of the child. So that's the commissioner's commission, very broad. They are also mandated to take reasonable steps to involve children themselves in this process of evaluation. How is proposed legislation going to impact on children? The commissioner, in fact, issues what's referred to by some NGOs as an impact statement, assessing how children's interests might be affected by government policy and action. In performing this task, the commissioner of necessity has to do some kind of investigation in order to prepare this report on issues of concern to children. In addition, the evaluation is subject to comments and criticisms by NGOs and by others who are interested in children and children's rights. So again, you see this process, this ability to have interaction and dialogue. In Northern Ireland, I had the opportunity to see how academics and NGOs were pulled into the process to evaluate the legislation under consideration, and also how academics were used to develop innovative methods to secure the opinion of even the youngest children in their situation. How did they perceive their situation? What did they want? What did they see as necessary? I saw how a thorough and thoughtful approach to issues involving children could in fact be produced, and how it could produce really wonderful suggestions for reform. I tried to imagine what our welfare reform debate in the United States would have looked like if this commissioner process was in place when things got done here. What would have happened if we had carefully studied the problem and our politicians had to take the resulting widely published results seriously? The carefully considered factual report was the subject or object of policy and political debate, rather than the distortions generated by the political grandstanding, by the appeals to the worst bias and prejudice of the American people. It is our process that has given us such fictional characters as the welfare queen who rides around in her Cadillac, living high off the largesse of food stamps while she models for her bastard children a life of dependency on the overburdened taxpayer. Such inaccuracies might have been exposed as lies in a process designed to focus objective inquiry into the actual impact on children of severe limitations on welfare entitlements, consider the proposed cutbacks in terms of their rights, the children's rights to make claims against society, what would have happened if that was the central concern rather than this fictitious welfare queen. In thinking about the difference the CRC and the commission process might make in the US, I was struck a few weeks ago by reading an op-ed piece by Bob Herbert that he wrote for the New York Times. Who Isn't Against Torture was the name of it. Mr. Herbert criticized President Bush for threatening to use the very first veto of his presidency to kill a defense authorization bill because it contained an amendment introduced by John McCain that would have prohibited the cruel, inhuman, or degrading treatment of prisoners in the custody of the US military. This amendment passed the Senate, this is astonishing to me, on a 90-9 vote. As Senator McCain noted in arguing for its passage in the Senate, the language of what is prohibited by the amendment tracks the language in the Universal Declaration of Human Rights, adopted in 1948. It's found in the language of the International Covenant on Civil and Political Rights, as well as in the Convention Against Torture. Senator McCain's case was also bolstered by a report prepared by Human Rights Watch, an NGO group that monitors human rights. The report indicated that members of the 82nd Airborne Division had routinely beaten and otherwise abused prisoners in Iraq. The Herbert column also included quotes from the Washington Post condemning the Bush threatened veto. Other newspapers and commentators have also taken up this cause against torture as a violation of human rights. What's interesting to me about this little tale of rare Republican resistance to the conduct of the military in Iraq is the way that the language of human rights both generates and then organizes the opposition to a certain set of practices. This opposition resonates across our society right now, reflected in the press, in governmental actions, in the activities of NGOs, and in public opinion polls. Perhaps successful organization is there for this because there is a rights talk, because we have these international treaties with which to frame this questionable behavior. The insight that rights talks is powerfully politically, even if the society is divided about the exact nature of the scope of the right, helps us to understand why so many people seek to establish the concept of children's human rights. Rights are more than legal concepts. They are important and powerful political tools that can facilitate calls to justice. Thank you.
Good morning. It's a privilege for me to be here, and a challenge to try to make a contribution to a conference that has already had so many outstanding contributions and presentations, including Professor Feynman's just now. I was invited by Professor Whitty in the late spring, I think, shortly after my book, What's Wrong with Children's Rights, was published. And I don't know if the name of this conference was, if this conference was named before or after he had seen my book. But I know I was invited with an understanding that I was going to make an argument about what is wrong with children's rights, whereas I took the title of this conference to be, how could there be anything wrong with children's rights? So I guess I'm here with the understanding that my role is to be a little controversial. I think at the end of the day I'm going to disappoint Professor Whitty by taking some of the air out of the balloon early on and saying that I would be pleased if the United States ratified the convention and joined the world community. I'd be even more pleased if the United States joined the world community in many other capacities and return to a point in history where this country considered itself partners with the world rather than the arrogant leader or individual path maker that it is rapidly becoming. I quickly moved from children's rights to politics, partly because my job is to be a little controversial, but partly because my point about what's wrong with children's rights is that it has the tendency to ignore more basic truths and problems about, at least I'm not an internationalist. I don't know a fraction of what Professor Feynman does, and I'm probably among the people she could properly criticize for paying too little attention to the world. But I know domestic problems, and I'll focus on them. Let me begin by providing you with a brief synopsis of the central theme of my book, and then hopefully take us through a connection of that analysis to the question of the convention, including why I'd be pleased to see the United States ratify it, but I do want to make quite clear that ratification won't change the problems that I'm going to be talking about. There have been two children's rights movements in American history. The first one began sometime in the late 19th century and survived into the first several decades of the 20th century. It was part of the progressive movement. Its significant contribution to American practice was the creation of juvenile court, and it accomplished a quite remarkable transformation of understanding of society's obligations to children. It was a movement based on a notion of children's needs and interests. Rights played almost no role in the movement. It was outside of its rhetoric. The second movement began in the 1960s and, interestingly enough, reached its high water mark in terms of judicial decisions in the 1960s, and things have been pretty much downhill ever since. The movement was officially recognized as being prominent when the Supreme Court decided in re Galt in 1967, declaring that children have a variety of vitally important constitutional rights, at least when they are accused of being juvenile delinquents in juvenile court. I want to suggest that the last 40 years of work on behalf of children's rights in the United States, having been advanced on a theory of the notion that children are rights holders, has actually been a source of great danger and little good. The argument of many children's rights advocates rests on a fatally flawed premise, in my opinion, namely that of the child's individual personhood. This premise falsely suggests the possibility, and even worse, the desirability of isolating children from the larger fabric of the society into which they have been born and are being raised. I'm particularly troubled that a leading characteristic of the children's rights movement is its propensity to separate children's interests from their parents. I believe that that effort constitutes the most egregious effort of the children's rights movement. And I fear that in the effort to make children more free vis-a-vis their parents, the government makes children less free in their relations with the state. I strongly endorse the American legal traditions that cede to birth parents the right to have the care and custody of their biological children and the primary authority to control the details of a child's upbringing. These traditions serve the sensible goal of providing children with their best chance to grow and be supported within a family. This familial freedom, unfortunately, has been deeply threatened by children's rights activists, seeking to wrest from parents some of the control they now have under current law, and then typically to transfer that control to judges, caseworkers, and children's lawyers. When these professionals supplant parents, they typically defend their decisions as necessary to protect children's rights and to secure the best interests of the child. I'm skeptical of such rhetoric. Children's rights has become a mantra invoked by adults to help them in their fights with other adults in all sorts of contexts. Children's rights has become a useful subterfuge for adults seeking to hide their own motives. And through the appeal to the best interests of the child, and though that appeal seems alluring and child-friendly, it is a formula for unleashing state power without any meaningful reassurance of advancing children's interests. It means substituting the state's preference about some aspect of child rearing for the parents. But this hardly suggests the second opinion is better than the first. Substituting a court's view of the best interests of the child for the parents only ensures greater intervention through protracted litigation. And as a consequence, children become ever more subject to state power. Now, as I say, that is the synopsis of the thesis of my book. It turns out, happily, that the convention does not contribute in any direct way to continuing that problem. And it is for that reason that the convention could easily be ratified by the United States, consistent with my fears and concerns. But it is equally true that the convention is full of the kinds of rhetoric that would permit the United States to continue on its course without any slowing down from what I see over the past 40 years as a very troubling trend. Among the things wrong with rights for children is that there is little to suggest under American law that an increase in children's rights translates to making things better for children. The basic problem, as Professor Feynman has just said, is that rights, for most purposes, mean something fundamentally important to those who get them, usually empowerment, autonomy, freedom. And we rarely mean those things for children, and even the convention rarely means those things. Instead, it is really about some adult making the decision. And America lags in the world in many things when it comes to children, but it is the leader exponentially in one particular category. There are more lawyers for children in the United States than in the rest of the entire world combined. Now, if we sign the convention, we can expect ever more lawyers and ever more state officials making decisions for children. Article 3, as we've heard several times over the conference, provides that in all actions concerning children, whether undertaken by public or private social welfare institutions, courts of law, administrative authorities, or legislative bodies, the best interests of the child shall be a primary consideration. Who could be against that? The problem is that this proves to be nothing but a formula, a Rorschach test, if you will, for the person responsible for enforcing that principle to do as she thinks best. And the remarkable thing about that formula is that that is ordinarily understood to be the antithesis of law. Law is supposed to be about constraining power and about clarity of rules. And for better or worse, the best rule we can come up with for state officials who are authorized to make decisions about children is do what you think is best. Now, in a homogeneous society, it's quite likely to hope, it's reasonable to hope, that state officials will think of the children before them and the children's parents before them as being almost like their own family, and certainly like their neighbors. And in that world, the possibility that the state official will behave in a manner that is just and fair and reasonable and appropriate is reasonably high. But those features do not characterize the United States of America. We are a deeply divided land. We are a land of the haves and the have-nots, the land of the politically important and the politically insignificant, the land of white, the land of brown and black. And in that world, in the real world of the United States of America, this authority for best interests of the children decision-making by state officials commonly translates into the least powerful and most vulnerable families and children being treated differently and far worse than a just society should consider appropriate. Now, American law, of course, is based on protecting negative rights, as President Carter stressed yesterday, and quite interestingly revealed that his own conception of rights was remarkably narrow, even through the point that he left the White House. And it took his passport and travels to the world to understand there's another way to think about rights. And to the extent that the convention is that other way, I support it. We can try to shoehorn into the current American conception of the role of courts a positive version of rights for children. But let's understand how swift the current is flowing against us. As we join an extremely aggressively fought campaign to keep judges out of politics, to prevent them from legislating from the bench, to ensure that they only enforce the law and not impose their vision on what is right, children's advocates who enter this fray are very likely asking to get involved with more than they can handle. This is, of course, the stuff of Roe v. Wade and the deeply contentious issues in American discourse which have brought new meaning to red and blue. Let's look realistically at how courts handle issues concerning children and their rights. A fascinating characteristic of the children's rights movement over the past 40 years, which is to say my career, is that children are demonstrably worse off today than they were 40 years ago across a wide swath of examples. Let's take, for example, juvenile and criminal justice. 40 years ago, when the movement started, it was unimaginable that children would be subject to adult prison terms on a routine basis in the United States. Today, we, until a few months ago, executed juveniles. We continue to sentence them to life in prison without parole in violation of the convention. And we routinely sentence juveniles to 40 and 50-year sentences. And it turns out the courts have nothing to say about that. The rule in American law is if that's what the legislature wants to do, that's okay. In the area of child welfare, there are more children in state care today than was imaginable 40 years ago. And since 1997, it is an official goal of the United States of America to permanently sever the parental ties of children who are state wards when they've been state wards for more than a very short period of time, 15 months. And we are the greatest social engineer of reforming new families, this a country based on a principle of family values. In the area of divorce, more children today are subject to protracted, expensive litigation with 3 lawyers in the courtroom because children have the right to be represented in so many jurisdictions, wasting resources that should go to them, that instead go to the industry that benefits from that principle. We rank 16th in the standard of living in the world for our children. We rank 11th in the world in the proportion of children living in poverty. Of all industrialized nations worldwide, we have the highest child poverty rate. And of course, this is not simply an accident of fate. Many countries have developed a very different set of priorities and policies with respect to children and families. Through the combination of guaranteed Social Security and Medicare, the U.S. ranks near the top of the world in longevity and wealth of people over the age of 70. By contrast, children are twice as likely as adults to live in poverty. Now, the children's rights movement is troubling to me because it saps so much energy from the political process into the legal process. It calls for you, It beckons you, if you care about children, become a children's rights lawyer. And I want to say that's a false message. We need children's rights lawyers, to be sure, but they are not going to pierce the most serious problems facing the United States of America with respect to its children. The United States is an excellent place to be rich. Back in 1980, the average American chief executive earned 40 times the average manufacturing employee. The rate now is about 500 to 1. By comparison, it's 24 to 1 in Britain, 15 to 1 in France, and 13 to 1 in Sweden. American children aren't even promised health care. Now, of course, the convention says they would get it. And to the extent that the convention is a principle of human rights, it would be impossible for me or unimaginable for me to oppose it. Martha Minow has written that human rights in the international sphere depend upon the development of a community that believes in them, rather than an authority that will enforce them. Organizing to influence and shape such a community may line up means and ends in precisely the way most important for children. Without adults who believe in the importance and entitlements of children, no convention, now I'm parsing my words, will alter these conditions. The strength of this convention and its movement is precisely that it depends on the willingness and commitment of adults to secure them. This is a deep meaning of rights. The problem is that lawyers speak to a very limited community. It tends to be judges. And judges are constrained by ideas and practices that are not going to change as a consequence of ratifying the convention. My problem is that children's rights as a concept, my problem is not that children's rights as a concept has done so little to advance the lives of American children. It is that despite having reached its zenith in the past generation, in terms of familiarity of phrase and the professionalization of children's rights advocates as a force in American discourse, the well-being of children over this period has palpably gotten so worse. I end with a quote from Alfred Kashudin from a little more than 30 years ago. Unless we are concerned about justice for the parent, we may be unlikely to achieve justice for the child. And I leave with you the notion that those of us who care about children must care about social justice. To the extent that the convention will advance our effort to that wonderful end, I do support it. Thank you.
Thank you both very much for your comments. We'll now have an opportunity for questions from the audience. There are 2 microphones in the back, and if you'll raise your hand if you have a question, the microphone will be brought to you. Please speak into it because this is being recorded. And also, please keep your questions brief. Looks like you all covered the waterfront. You have a question down here?
I'm Winnie Worrell. I work for DeKalb County Department of Family and Children's Services for 30 years. And I started out actually I had worked for legal aid prior to that as a paralegal. And so they quickly made me the hatchet lady, which was the termination lady in foster care. But, and let me say that I did a lot of terminations of kids who had been in foster care for a good number of years, and did older children adoption. But I do take issue with the very short time that they have required us now to make decisions and terminate rights on families that have hardly had a chance to get, we've hardly had a chance to get to know. And certainly when you talk about addiction and mental health issues, even sorting that out within 12 months or 15 months, as you mentioned, is very difficult. Luckily, we do have citizen panels in Georgia which help us make those decisions. But anyway, we do need to move on with children, and I do support that. I did want to make one comment, and I'm sorry, in terms of where our issues are, it's particularly with schools and the requirements of testing of children constantly, and yet we don't look at the family situation from where they came. And I guess what I'm saying is we're expecting children to do well without assisting the family situation at home. And we know that children from low socioeconomic level families do have more issues, and yet we're not doing wraparound services for those families which may have issues of depression that they're treating with alcohol and other drugs, and also learning disabilities themselves, so that they're not qualified to help their children with their learning disabilities. And yet we don't seem to, as a society, be working with those families. So I just wanted to mention that if you have any comments.
Thank you. Beth?
Yeah, this is for Professor Guggenheim. I guess listening to you here today, there's plenty that I agree with, but what strikes me overall is almost that what you're putting forth is a red herring, that you're blaming courts, children's lawyers, rights for children, for what is actually, to me, the bigger problem, some of what you acknowledge: poverty, apathy, a lack of social justice. And so, while I certainly agree that we've got to have advocates out there working on those bigger issues, I'm really worried about, in the meantime, I guess I'm worried about people taking what you say and running with just essentially lawyers for children are bad, hearing that message, though I know that's not what you're trying to say. And so how, in the meantime, while we work on poverty, social justice issues, do we protect the child with the substance-abusing parent, the chronically mentally ill parent, the violent parent? And so if you could just respond to that, I'd appreciate it.
Well, it is a dilemma. My large point is that working on those problems matters as we see real children is a natural good desire and instinct. But we've drained out of the children's rights movement the social justice claim. Children's rights advocates are not pressing Congress for better preschool program, for health care screening, for the elimination of environmental racism, for decreasing the problem of asthma in many communities, for ensuring that children get dental care, which often corresponds to problems in school, for social justice for their parents. That's not their issue. They're only representing the child. It must become our issue. Now, I'm not answering your question. I'm not condemning the person who cares about an individual child that she comes across. I'm condemning an effort in this country that allows us to treat each problem as isolated unconnected to a larger agenda. And that larger agenda, I would suggest, includes making you feel that the proper thing to do is to worry about this individual child and not something broader. Politicians who don't want to invest public dollars in improving children's lives on a macro basis encourage the intervention on an individual basis as a means for avoiding the investment that social justice requires. So my point isn't to be critical of the children's lawyer. It's to be critical of our having accepted this very modest role as the only means by which we can help children.
Do you want to respond as well?
Yeah,
Hi.
Do you have another response to this question?
no, I just wanted to say, I agree that what I'm interested in is changing the political culture, and I think you don't do that one case at a time. And in that regard, it's really interesting that so if you want to change the political culture, you can't do it one case at a time. It seems to me that's right. But I'm interested in the restrictions that have been placed on legal aid, for example, about bringing test case litigation and class actions and that sort of thing. So actually, as a political matter, it's been structured in so that the lawyer for children can have a broader impact. But I am a bit concerned about the confusion of lawyer for children with advocate for children, because while an advocate may be a lawyer, I think the advocacy role is much broader and actually addresses the kind of systemic and other kinds of problems that we're both concerned with fixing. I consider myself to be an advocate for children, but I do not handle any cases whatsoever, would be incompetent to do so. And I think that there's a very broad and vital advocacy for children movement that's really directed at the social and the injustice and that sort of thing in the United States. What we need are tools, and the tools don't exist, and I think that that's really unfortunate.
Hi, I'm both a single parent and a foster parent. And my concern is, as both, where do I look to for accountability for the combination of children's rights as well as parental rights? Because I feel like as a parent, as well as a foster parent, the two have to be yoked together for effectiveness. So where do I look for that accountability? That's my question.
I don't know. What we have done in child welfare since 1974, when the Child Abuse Prevention and Treatment Act was enacted, was stress the pathology in the family as the justification for assisting poor families, and take completely out of that analysis any appreciation, any claim that society or government has contributed to the family's inability to raise children safely and well. As a consequence, we not only have welfare queens in our common mind, but we have the idea that too many parents in this country are very bad for their children. Now, I don't disagree that there are parents who are bad for their children, but we know that that is a fraction of the story of child welfare. But that is not a common understanding in this country. Child abuse, as meaning parents harm their children, is thought of as the most serious threat to children in the United States, deliberately so, as part of a plan. It's not true. Guns are more dangerous to children in the United States. We don't link the proliferation of guns to children and their rights. That would be out of bounds. We'd be getting into, wow, talk about Roe v. Wade. Now we'd really be into a serious political fight. We've been required to cabin what it means, what children and their rights mean, by forces that are pretty smart at figuring out how to keep us divided and how to maintain a society that doesn't serve children very well. How you bring the two together, we need a social movement. We need a political movement. We need a commitment to care about children the way the Western European countries do and the way we refuse to.
Here and then up in the back. Oh, okay.
Thank you very much. I'm Landon Pearson from Canada. I wanted to express my appreciation for both of you. Those were tremendous presentations, and I've learned a great deal from it. But the question that you raise in particular, Professor Guggenheim, is the question of best interest. I wanted to make a reference to that. We've been struggling with this in our setting, and I remember speaking to a young offender some years ago who said, "Oh my goodness, every time I hear best interest, I know I'm in trouble," which really expressed very well what we were thinking. So what we've been trying to do is define best interests in very, very specific ways, so that when a judge or someone else is making a determination for that child, it's very clear what you have to check off. And one of my more difficult political experiences was as the co-chair of a joint parliamentary committee on custody and access, and I had no idea. I know exactly what you're talking about in terms of the three lawyers and the voices in the courtroom and the degree in which the adversarial system enhances or magnifies the pain of the child. So we came out with a report called The Best Interests of the Child. It's been a little bit time getting itself now made into legislation, but we will be reforming our Divorce Act. Hopefully it's going to be in Parliament this fall, in which the listing on best interests of the child is going to be significantly enlarged to encompass all the kinds of things that we're talking about. So it's not going to be vague. So, you have to think about a whole lot of things. I think that's one way of trying to address it. The other comment I wanted to make was that we have used the Convention on the Rights of the Child to reform our youth justice system. And I think that the way in which because we were moving a bit in your direction and having far too many kids in close custody. But in our latest youth justice strategy, we are emptying our custodial by diversion and all kinds of other things, trying to genuinely think about how to help those children keep in touch with their communities, in touch with their parents where it's possible, and so on and so forth. So I think that I was pleased at your final comment about the convention, because I think it does become a tool to make things better for kids if you don't have such a contrary culture to deal with. And so, we learn from you, but we learn both positively and negatively. Right. Both of you have analyzed your situation brilliantly. I don't need to comment further. Thank you.
There's a gentleman in the back who's been waiting.
This is a question. I'm Richard Roselle, a lawyer in private practice, and a question for Professor Guggenheim relating to the point you made about the difficulties arising from the multicultural sensibilities in the United States and the way that impacts on parental decisions affecting their children. And to me, that focuses on a critical issue in which a substantial argument that you haven't made can be made for an activist society, and that is we have a multicultural society in which a substantial body of parents believe that girls should be clitorectomized, that children should be disciplined by being beaten with sticks and whips, that girls, whatever their age, and particularly under the age of 18, should have no access to abortions, that girls who have sex outside marriage dishonor their parents and should be killed. You know, there's a specific, that's not a hypothetical, that has happened in the United States, resulting in criminal prosecutions. So the fact is, every parent in our society is part of a larger society which makes judgments about what parenting should be. So what's your argument for why society should not, through a judicial or rights system, preclude parents from making decisions which the larger society believes in these, to me, critically important areas should not be a legitimate area for the exercise of parental authority?
Well, that's a very important question and subject, and I do support laws that constrain parents from engaging in practices defined carefully as being prohibited. And the examples you mentioned fall within that category. Obviously, a parent who attempts to harm a daughter who had sex before marriage would be violating the criminal law and should be prosecuted for doing so. I don't think cultural boundaries should extend so far as to immunize that behavior. And the examples you mentioned, adolescent abortion subjects a little more complicated, are examples of U.S. law prohibiting those practices. I support that. My broader point about the cultural diversity in this country is that too many people with power despise the parents of the children about whom we're speaking. What are we going to do to change that? Until we change that, we haven't come close to addressing the true issue of children's rights. President Carter's final remarks yesterday: peace, justice, generosity, active respect for all people. That does not characterize the United States of America. And until it does, children's rights is in trouble.
We have time for one more question. Actually, there's been someone waiting in the back.
Hello, I'm Amy Totenberg, and I'm an adjunct faculty member here, but I spend the largest percentage of my time as a special master for the federal courts, overseeing city school districts that have been declared to be functioning in violation of federal law, in particular the special education laws. And one of my perceptions, in having spent now years doing this, is the degree to which we do divide the kind of conception of education rights and the view and understanding of where children can go through the education system and the bundle of social and economic issues that we have addressed here. We see educational advancement as the panacea en route to advancement and escape from poverty, and yet we don't address the root poverty conditions. And it's the thing that, of course, drives teachers crazy as well, that they are trying to function in an isolated context. And right now we really are functioning in our political analysis in a very fragmented way. We look at education. We haven't mentioned education virtually at this point here today, versus the bundle of oppressive conditions described for children right now. And so education, there are a host of educational rights that children do have in our country. And I think it is very important that we begin to address these issues, though, in connection with the broader social issues that we've been talking about. And but we haven't. I mean, I think that we allow the discourse to be education only, without the rest. And I'm not sure how that can be addressed, other than the broader issues that you've raised, but I do want to, because so many, I think the reason why lawyers go into the individual cases that you're talking about or go into education or are interested in education is it does provide an avenue for addressing these concerns. And no matter, while we need to be addressing the broader issues, the fact is we're practically looking for how can we address these the problems that children face, and so we go on our segmented routes. But it is to say only that I wanted to comment and also provide you an opportunity to talk about how we might be able to more broadly connect the host of legal rights and focus that we give to education for children and the bundle of activities that are occurring on the social welfare side.
Thank you.
I'm glad you brought up education because we only had a limited amount of time, so you can only talk about so much. But in the context of looking at children's rights, the way I would like us to look at it as a political matter, education is interesting because I agree it really reflects larger social problems in this country. For one thing, in terms of education, what we're really talking about when we talk about children's rights is parents' rights. And what I would like to see is a reconsideration of Yoder, Wisconsin versus Yoder, or Yoder versus Wisconsin, whichever way it was, simply because as long as you allow parents to pull some children out of the public school system, what happens is this creation of a private system which in fact takes resources away from the public system, including support for a strong public educational system, harming many children in doing that. It also subjects those children that are now in the private system to the kind of discriminatory treatment that was mentioned earlier. So what if instead of talking about genital mutilation for girls, what we're talking about is an educational system that tells them that they're inferior and unequal and should be subservient, and that's what they're taught every day in the context of a private school education. So that all of those problems actually kind of converge in the context of education. So if we were to think seriously about children having rights independent of their parents and the state having responsibility in regard to the long-term best interests of children, I hate to use that term, then we might worry about how they're being prepared to realize their full capacities as adults, how they're being educated to live in this modern world that we recognize. So I have actually written about this and argued that we should have a mandatory public education system that actually makes us share certain kinds of instruction across all of society that can be supplemented by religious and other kinds of education to actually give some credibility to parents' rights in that regard. So trying to actually reach a compromise position. But the educational system is key because, as you say, that's what we use to justify existing inequalities. It's possible to educate your way out of it, but in fact it's not. It's not in the way the system is currently structured.
I hate to end the conversation, but unfortunately we have come to the close of our time. I invite all of you to continue the conversation during the break, and we will return at 10:45 to resume our conversation as a group. Thank you.
The preceding program is copyrighted by Emory University.